Hello, welcome to the 36th Legislative District Democrats. We are here today with Sharonda Amamilo, candidate for Washington State Supreme Court, position 5. Go ahead with your introduction.
Thank you. Good evening, and thank you for the opportunity to be here. I'm Judge Sharonda Amamilo, and I serve on the Thurston County Superior Court. I'm also a wife, a mother, and a grandmother, and my path to the bench reflects a lifetime of work, service, and a deep commitment to education. My grandmother taught me to read before I ever entered school, and that foundation shaped everything that followed. I became the first in my family to attend college, earning an associate's degree, a bachelor's degree, a master's degree, and a law degree, and a graduate certificate in data analytics. In my family, education has always been about the opportunity to be responsible. I also served our nation for over 30 years in active and reserve military service in national security roles, retiring as a Chief Warrant Officer 4. That experience instilled discipline, analysis, accountability, and a deep respect for constitutional principles. And my working life began as a Wendy's line staff worker and continued through roles as an office clerk and a cleaning technician, all the way through a clerk typist at the Department of Labor for Black lung claims. As a grandmother-in-law student, I entered the legal profession first as a general practice attorney and then as a public defender, and now as a judge on the bench. I preside over a full general jurisdiction docket, thousands of cases, thousands of times touching lives, touching everything that's important to people, from education to housing to work to having the custody of their children. And I'm running for the Washington Supreme Court position 5 because I bring independent judgment and a collaborative approach, working thoughtfully with my colleagues to deliver decisions that are principled, transparent, and rooted in the rule of law. And I aspire to earn your endorsement and your trust in this work. Thank you.
Thank you so much for that introduction, and I apologize that I forgot to use your honorific. We are here with Judge Sharonda Amamilo. Now we have our 4 prepared questions, and Joanna is offering the first one.
Hi. How would you approach cases asking to overturn longstanding judicial precedent, especially for cases that were decided long ago when Washington State looked differently than it does now?
Absolutely. The starting point for any analysis involving precedent is the doctrine of stare decisis, as you all well know, which promotes stability, predictability, and public confidence in the judiciary. It's all about trust of the system that we hold so dear to make sure our protections remain in place. And that requires consistency as long as it doesn't cause harm or was deemed completely incorrect. And that addresses the issue of time. That said, precedent is not absolute. Courts consider several discipline factors when asked to revisit prior decisions, whether the prior decision is clearly incorrect as a matter of law, whether the decision has proven to be unworkable in practice, and whether the legal or factual developments have undermined its foundation and the extent to which reliance interests would be affected. We think about the child welfare laws as relates to native peoples and their children. It's also important to distinguish between changes in society and changes in law. Courts are not policy-making bodies. Our role is to interpret and apply the law with constitutional bounds, and any reconsideration of precedent must be approached with restraint, careful analysis, and full briefing. It requires an independent assessment grounded in the record and the law, and informed by respectful, open-minded deliberation with colleagues on the court. It is an important question. We must be careful and we must adhere to the law unless we can meet the very high bar that is grounded in our Constitution so that people continue to trust the courts and can count on the judiciary to not legislate from the bench. Thank you very much for the question.
Thank you. And our next question is coming from Anita.
Artificial intelligence, or AI, is not always a well-defined or understood term. How do you define AI? And how do you think that courts should approach using AI in day-to-day operations?
Thank you. Artificial intelligence, broadly understood, refers to computational systems, really. It's a process that speeds up the process of reading and synthesizing and sussing out what's actually in dispute and cognizable under the law, and whether or not you can identify things that have remedies under the law. In the judicial context, it is best understood as a tool. It is not and can never be a decision maker. Courts should approach AI with both openness to its administrative benefits and caution about its limitations, because you have to consider the database. And with over 30 years in the military intelligence arena, I am a master at querying raw databases, and I understand the value of what goes in impacts what comes out. And we have to ensure that we are recognizing that there could be biases embedded when we allow AI systems to make decisions. And that just can never be a replacement for the independent decision making of a judicial officer, of evaluating credibility, weighing evidence, interpreting the law, and exercising discretion. Those things require human judgment. They require accountability to that human, the judge or justice, and transparency, and those cannot never be delegated. There are also important considerations around accuracy, bias in training data, confidentiality, and due process. And any use of AI in the courts should be guided by clear ethical standards, rigorous validation, and safeguards to ensure that the integrity and independence of the judicial process is preserved. Thank you.
Thank you. Our next question is coming from Howard.
Hi. The
Hi.
Harvard Crimson recently reported on an emerging two-track clerkship system aligned on ideological grounds with a distinctly different path to clerk for liberal versus conservative federal judges. How does ideological alignment impact the work of a judge, and how can we create and protect a nonpartisan bench? Since electing judges is an inherently political endeavor, how do we ensure that judicial races do not become de facto partisan?
Absolutely. You ask the types of questions that you all are asking and hold people to it when they answer them once they are on the bench. Judicial decision making should never be driven by ideology. Under the Code of Judicial Conduct, judges are required to decide cases impartially based on the law and the facts presented. Clerkships, at their best, are about rigorous legal analysis and professional development, not ideological alignment. Judges set the tone, though, by fostering chamber environments grounded in intellectual honesty, respect for differing viewpoints, and a shared commitment to the rule of law. Maintaining a nonpartisan bench, particularly in an elected system, requires discipline and clarity about the judicial role. Campaigns may involve engagement with the public, as we are doing here, but once you're on the bench, the obligation is singular: to apply the law without favor or bias. Transparency and reasoning also is very key. When decisions are clearly explained, anchored in statute, precedent, and constitutional principles, it reinforces the public trust that outcomes are driven by law, not personal or political preference. And ultimately, the safeguard is the judiciary's adherence to its core function: independent judgment, exercised with the collaborative court, and where each justice brings their perspective to a shared principled analysis. I, as a trial court judge, build the record that goes to the appellate level. Sometimes cases go from the trial court straight to the Supreme Court if the urgency of what the impact might be on the entire citizenry of Washington State. Sometimes cases go to the Court of Appeals before they go to the Supreme Court. But in all those instances, those cases come from the trial court record. Nothing is added to it from the record. And at the trial court level, we are also reading historical appellate cases, historical Supreme Court cases, and we are embodying that in our protection of people's rights at the trial court level. Thank you.
Thank you. Our last question is coming from Pat.
Okay, tell us a little bit about continuing education requirements for judges. How do you proactively seek out furthering your knowledge and understanding of issues like bias, diversity, inclusion, and accessibility? And how have you applied these to your own work?
Thank you. Very good question. Washington judges are required to complete ongoing judicial education through programs supported by the Washington State Administrative Office of the Courts and related institutions, other national institutions, the National Institution for Juvenile Justice, National Institution for Drug Courts and Therapeutic Courts. So all of those things qualify to make sure that we are aware of all the things that might be seen as red flags for bias in the system. And these programs cover substantive law, ethics, and emerging issues affecting the course. Beyond those requirements, I actively seek additional learning, particularly in areas involving implicit bias, trauma-informed practices, and cultural competency. I've taken courses in all of those things, as well as made myself available to teach and support conversations. I was the moderator from Thurston County for a Kitsap County moderated conversation between the community and local law enforcement as an outsider, so that the people could speak freely and not worry about what might be the repercussions of those conversations. And in practice, those types of commitments translates into how proceedings are conducted. It includes ensuring that litigants understand the process, maintain courtroom environments that are respectful and accessible, and being attentive to how has both explicit and implicit bias affects perception and your decision making. At the same time, the role of a judge is not to advocate, but to apply the law fairly. Education in these areas supports that role by strengthening impartiality. It strengthens self reflection, and not replacing anything, but it makes sure that you have an impartial lens that's being constantly tested to ensure that you're not harboring bias that you may otherwise not pay attention to. And it helps to ensure that decisions are both legally sound, clearly understood by those impacted, because a justice system that has everybody on high alert for implicit or explicit bias is a justice system that takes us that much further and closer to justice for all. Thank you.
Thank you so much for that. And now we have some time for some follow-up questions, and you will have 1 minute to respond to each of those. And I'm going to go ahead and take the first one. You mentioned that you have 30 years of military intelligence experience. Thank you for your service. And
You're welcome.
can you tell us a little bit about that and how that research lends itself to your work as a judge?
Absolutely. And that combined 30 years is active duty and reserves, while being a lawyer, while being a judge, while being, and prior to that, in my tenure, I was tenured faculty at Bates Technical College. So my whole, people say you couldn't have been in the military that long. Yes, I have, over the course of my life, but that because of the critical decisions that I had to make, and I had to advise people who were making further decisions down the road that put people's lives in danger. The soldiers, I've been deployed before, so when I deployed, I deployed with the division, and that's where the generals are, and the generals are then sending commands down range. And it's being able to operate under pressure, being able to synthesize large volumes of raw data, being able to articulate under the rules of under the law the way in which a decision can be then effectuated on the battlefield, helps me understand the crises that people have that bring before the court. And so it is very compatible.
Thank you for that.
You're
Our
welcome.
next question is coming from Howard.
Hi. So, just expanding on the fourth question. In 2020, the Washington Supreme Court issued a groundbreaking letter addressing a very strong position on systemic racism and racial inequity in the justice system in light of George Floyd. So, if you could just expand on that as a Supreme Court justice, if you would continue that practice, and maybe where you would go with that. Thanks.
I would. Thank you very much. I appreciate that, because what I took that letter as giving me permission to make sure that bias is called out in its present tense when it's happening in my courtroom, when there's a disparity in how one litigant is being treated, especially in state versus Jane, Ann, John, whoever, Doe. In those types of cases, just to call out, well, this case was treated this way, and this case is being treated differently. We have similarly situated persons to be able to call them out. I also worked with our court, established, and we had an equity committee, but what we did after that letter is we pulled down all of our protocols, all of our processes, all of our local rules, and we filtered them through that lens again of bias that we may or may not have been aware of, to make sure that we were not practicing or being complacent. And so we have a heightened vigilance and a heightened awareness. Thank you.
Thank you.
You're welcome.
I have plenty of other questions for you, but I just want to pause to see if anyone else had one before I launch into those. Okay, I'm not seeing hands. So I was
I'm
hoping that
curious to
you could.
hear what your questions are.
Oh, well, I will tell you. No, one of the ones I'm always curious about is what is it that has drawn you to be a judge, and what are some of the more interesting things or things that most people wouldn't know about being a judge?
I think most people wouldn't know, at which I was surprised to learn as a judicial officer. When I became a judicial officer, is just how much time judges spend not on the bench, working pedal to the floor, either in the community, making sure people understand how the justice system works, or reading cases, deliberating, working with other justice system partners, trying to make the system better. I think people wouldn't know that. And then a nice surprise is that to take away people's fears about, okay, you're a career public defender. Are you going to be nicer to people that you of types of cases that you're going to represent? But what people don't understand is that whenever you're an attorney, you have to take a position and you go into court and you litigate that position. When you're a judge, you don't have any of that. You have to listen. You have to look at the law. You have to let it get filtered through. And then you use all the tools that are available to you to met out justice. And I think people really should understand that it is a calling to make sure that you are following the law and not having judgment when you having a prejudgment when you are before in the courtroom. I'm sorry, I went over your minute and the
No,
timer
no,
didn't stop.
that's quite all right because my last follow-up is related to what you just said. Talking about a judge's work happening outside the courtroom and
Mhm,
specifically what you do in the community and what
mhm,
that has looked like for you and how it would
mhm.
be serving statewide.
Absolutely. I think the biggest thing for me and why it's appropriate an appropriate question, judges have to get outside the courtroom to know what's going on in the whole system. And as a Supreme Court justice, it's important to have a perspective that knows what's going on in the whole system. I'm appointed to the Washington Sentencing Guidelines Commission since 2022. I've been on the Alternatives to Incarceration Task Force by the Board of Judicial Administration. I've been legislatively appointed to the Alternatives to Incarceration. I was recently appointed by joint legislative confirmation to the DCYF, Department of Children, Youth, and Families Oversight Board. All of those things. And I serve on a national anti-trafficking judicial peer group that meets every month, and where we're talking about all the things that would come before a Superior Court judge, all the types of things that would come before the Supreme Court. And I really work as much as I can to mentor other young lawyers and serve on panels to that effect with Seattle U, with the Bar Association, whenever I believe that I can facilitate much more knowledge to equitable justice. Thank
Wow,
you.
that sounds like a lot. Thank you. And now we have just an opportunity for a 90-second close.
Absolutely. Thank you again for this conversation. It's been wonderful. The work of a court of last resort carries significant responsibility, not only to decide individual cases, but to provide clear and consistent guidance that trial courts can rely on and communities can trust. My experience has been grounded in the day-to-day realities of the justice system, where legal principles meet real people and real consequences. That perspective informs my commitment to decisions, that makes me careful and transparent and firmly rooted in the law. I would approach this role with independence, humility, and respect for the collaborative nature of appellate decision making, engaging thoughtfully with my colleagues to reach outcomes that reflect both rigorous analysis and fidelity to the Constitution. And above all, I believe the judiciary serves best when it is steady, principled, and worthy of the public trust and represents all of us. Thank you. Thank you for this opportunity, for your time and consideration. And I would greatly um, appreciate the endorsement of my campaign for position 5, Sharonda for Justice.org. Thank you.
Thank
Thank you
you.
so much to Judge Sharonda Amamilo for coming in today, candidate for Washington State Supreme Court Position 5. Thank you.
Thank you.
Thank you. Nice to
Bye-bye.
meet you.